Are you
This matter
serious?
is concluded. You're free to go.
Who's
Have a good
sucking
day.
whose dick around here?
Hold-
No,
ma'am,
seriously.
Another 30 days for contempt of court. You're in jail for 60 days now. Good morning to everyone. This time and place set for the show cause hearing in this matter for contempt for failure to provide parenting time. I'll let you know we're going to take some brief, I guess, testimony from the parties. I'll let everybody know that everybody will have an opportunity to speak. So don't interrupt anyone else or don't interrupt the court. You'll have an opportunity to speak your piece. So on the we do have the show cause hearing. We also have the motion for change of custody and parenting time. I'm going to address the motion first because that will be the easiest matter to get resolved. So Mr. Kelly, you can proceed with your motion.
Your Honor, essentially, that motion is based primarily on the issues we've had ongoing in relation to compliance with the court order and my client getting parenting time. It's directly and impacts the child custody factors, and I'll name the ones that are impacted due to this withholding occurrence. The love, affection, and emotional ties existing between the parties. It looks at the emotional bond. Him being prevented from seeing his kids is preventing him to continue that emotional bond and nurture that emotional bond, which he had prior to this latest withholding that has started back on December 27th. Factor B, the capacity and disposition of the parties involved to give the child love and affection that focuses on the ability to, again, parent to foster an emotional bond in the future. He's having a hard enough time in the present, again, because she's not keeping in compliance with the court order.
The courtroom erupts in disbelief as the judge's patience finally runs out. What begins as a routine conclusion instantly turns into a stunning moment of authority. The judge makes it clear this matter is over and freedom is granted. But the defendant's reaction crosses a line no court will tolerate. Disrespect toward the bench is not emotional expression, it is contempt. In a single moment, the tone shifts from resolution to consequence. This is not personal. This is the court defending its authority. In this courtroom, words matter, and actions have immediate, irreversible consequences.
And he's not able to see these girls to be able to have a solid relationship and foster that relationship. The length of time they've lived in a stable, satisfactory environment, I'd submit to the court. Defendant's home is not stable, considering the allegations she's made that have been investigated by CPS twice, police twice, and both been denied. Nothing's come of it. Which leads me also to the moral fitness of the parties involved, which ties into the same factor. But we have to keep in mind, Your Honor, at the beginning of this case, he was charged with domestic violence in relation to her essentially going after him to get keys to his truck so she could get some pot and smoke it. As he's being arrested, she's telling him, "I want you to come home." He, of course, gets him on bond. He can't have any contact. Once the bond conditions get lifted, she's contacting him through text and saying, "Hey, let's me, you, and the girls get together and we can go to the zoo, we can go to a park."
Okay, Mr. Kelly, how does this relate to your motion?
It's related to, Your Honor, again, the moral fitness involved, as well as the stable, satisfactory environment.
The court now addresses a show cause hearing rooted in one core issue: failure to provide court-ordered parenting time. The judge carefully sets expectations. Everyone will be heard, but interruptions will not be tolerated. This hearing is not about emotion, speculation, or accusations alone. It is about compliance with lawful court orders. Before contempt is addressed, the judge moves strategically, choosing first to resolve the pending motion for change of custody and parenting time. The courtroom follows procedure, not chaos. Structure, order, and due process remain the foundation of every ruling that follows.
In that she's accusing him of sexually molesting these girls. But before all this, she's wanting him to come home. She's wanting a relationship with him. She's wanting her family essentially reunified. Those two things don't jive together, Your Honor. And I would think that essentially it's a fabrication, which would go again to the moral fitness and also to the mental and physical health of the parties, Your Honor. You're making these allegations, these terrible allegations, but on the other hand, you're still wanting the same guy who's supposedly doing this stuff to come into your house. Finally, Your Honor, the unwillingness and ability to facilitate and encourage a relationship. Again, this is the fourth motion we're here this morning on, Your Honor, for him to see his girls. She doesn't follow your court orders. She withholds them for no valid reason. And she's clearly shown she's not going to facilitate a relationship between him and his kids. I think that's more than enough that gets us over the threshold of a change in circumstance or a proper cause, because these things are having a significant impact on these girls' lives in terms of having a relationship with their mother. So
The father's attorney presents a focused and structured argument. He ties repeated denial of parenting time directly to statutory custody factors, emotional bonds, moral fitness, stability, and willingness to foster relationships. This is not framed as a single violation, but as a pattern of conduct. Multiple investigations, none substantiated, are highlighted to challenge credibility. The argument is clear: withholding children damages parental bonds and violates court authority. The request is serious: an evidentiary hearing, immediate temporary custody, supervised visitation for the mother, and court intervention to prevent further obstruction.
We would request, as part of our relief, that you set this matter for an evidentiary hearing. We're also requesting during the interim that my client get temporary parenting time starting today, and that he continue to have them until the evidentiary hearing, that mom's parenting time be supervised at her expense, because she's clearly shown an unwillingness to follow your rulings or to comply with your court orders. I think if you don't do that, she's going to take these kids and run, and we're going to be in a bigger mess than we are today.
Okay, thank you. Ms. Couch, if you wish to speak to the motion.
I had some statements, but it's just what I had submitted to the court.
Okay, go ahead, tell me, and then
Okay, would you like me to stand?
whatever you wish. If it's more comfortable sitting, go ahead, but speak up a little. So
Okay, I said that his first statement was true, but the second statement that he said was false. I said I previously tried to change parenting time because of the videos the plaintiff had been watching. It was reported to Penfield's police department because plaintiff was
The mother responds with deeply serious allegations, claiming abuse, investigation failures, and ongoing safety concerns. She references CPS, police involvement, therapy, and disturbing claims about the father's behavior. However, allegations alone do not override court orders. The judge listens but remains focused on admissible evidence presented today. Emotional delivery does not replace legal proof. While her fear is stated, the court must evaluate whether her actions, specifically withholding parenting time, were legally justified. The distinction between concern and contempt becomes central to the court's evaluation moving forward.
previously residing in Penfield. I spoke to their sheriff where we looked at the videos together, and he told me that he would be conducting a search and not to address the matter to the plaintiff because he would need time to get 2 search warrants, and the investigation was never done. The next statement is also false. On December 27th, after the children's bath, Amelia Conley was heavily touching her private area, and when questioned who touched her potty, she said her dada. On January 1st, Evelyn Conley stated that her dad touched her on the couch. The fourth statement is false. CPS is not taking the proper steps to ensure the minor children's safety, and I did mention police involvement in the last hearing as well. The fifth statement is also false. Errors were made by the plaintiff's attorney. The sixth statement is also false. There is supposed to be a pending CPS case, and I was never told otherwise. CPS and I have spoken on numerous occasions and decided that the best course of action was therapy, which the minor children are attending at Summit Point. I do have proof of all of that as well. That's also false. I was never told that they were declining to investigate the police. Number 8, It's false. In early
Testimony from the father and his mother establishes a consistent pattern. Parenting exchanges that once occurred peacefully suddenly stopped. Police involvement failed to resolve the issue. Doors were shut. Orders were ignored. Make-up parenting time was denied repeatedly. This testimony isn't dramatic, it's methodical. The court is not assessing who feels right, but who followed lawful orders. Each missed exchange strengthens the record. The evidence shows repeated defiance, not misunderstanding. At this point, the court's focus narrows sharply from custody arguments to enforcement and accountability.
Early 2024, my mom threatened to call CPS on me because of the children's odd behavior, requesting that I get them checked by the doctor. I had the doctor examine them at their 2-year checkup, and almost 2 months later, the plaintiff was arrested for domestic violence. I originally withheld the kids because of the plaintiff's sexual preference for diapers and enemas, knowing that the plaintiff was not mentally stable enough for unsupervised visitation. And I withheld the children again after finding videos the plaintiff had watched of children being abused, and the minor children were sexually abused during holiday parenting time with the plaintiff. The 9th statement is true. The 11th statement is false. The 12th, I'm unsure of the plaintiff's employment, but the plaintiff has stopped paying child support and I still stay at home with my children. Number 13, I have lived at the residence that the FOC has on file since December 10th, 2024. The 14th statement, I'm unsure of the plaintiff's relationship status. I have friends and family in Michigan, and I lived in Indiana until I was 18, and most of my family resides there. Number 15, I would like the court to consider changing the current custody orders and issue no further contact between the minor children.
The judge intervenes decisively, limiting irrelevant questioning and refocusing the hearing. This is not a trial on allegations. That day will come separately, if warranted. Today is about compliance. The judge confirms prior orders, dates, and missed parenting time. The record shows multiple chances, multiple warnings, and escalating consequences that were ignored. The court emphasizes a fundamental principle: concerns must be addressed through motions and hearings, not self-help. Taking the law into one's own hands is never an acceptable option in family court.